All right, if you are serious about a career in international law, there is a three-letter acronym you absolutely, positively have to master. ADR. That's Alternative Dispute Resolution. And today, we're not just going to define it, oh no. We are going to master the key English vocabulary you'll need to confidently advise your clients on it. So, let's start with this big question right here. I mean, think about it. How do you solve a major legal fight without ever stepping foot in a courtroom? This isn't just a hypothetical for a law exam, it's a real-world problem you're going to face constantly. And the answer? Well, it involves a whole toolkit and a special legal vocabulary that's completely changing the game.
So here's our game plan for today. First, we'll get clear on what ADR actually is. Then, we'll dive into the two heavy hitters, mediation and arbitration. After that, we'll uncover the core philosophy that drives the whole thing. Then comes the really important part for you, the key vocabulary. And finally, we'll wrap up by looking at how you, as a lawyer, decide if it's the right move, weighing all the pros and cons.
Okay, first things first, let's get a really solid handle on what we're talking about here. When we say ADR, what does that landscape actually look like?
Here's the most crucial thing to get right from the start. ADR is not just one single thing. Notice that great English phrase on the screen, umbrella term? It's a perfect description because ADR covers a whole range of different methods. But the one thing they all have in common? They are all structured, private ways to solve problems, away from the public eye of the courts.
You know, the idea of sorting things out without going to a judge is, well, it's as old as time, but what you're seeing here is how it became a powerful modern system. The real game changer? 1958, the New York Convention. That's the moment when arbitration decisions became enforceable across borders. It literally created the backbone for the global commerce we see today.
Okay, so now that we know the history, let's walk through the two main doors you'll find in the house of ADR. You've got mediation on one side and arbitration on the other. Now pay close attention here, because this slide breaks down the fundamental difference, and it comes down to two essential legal English words: facilitative and adjudicatory. Mediation is facilitative. The neutral third party facilitates a conversation. They help the parties find their own solution. But arbitration? That's adjudicatory. The neutral acts like a judge. They adjudicate. They hear the facts and then they impose a final decision. It's the difference between helping people agree and making the decision for them.
And you know, that difference between facilitative and adjudicatory is not just about process. It points to a much deeper philosophy, a core idea that really makes ADR a whole different world from a traditional lawsuit.
And this is it, party autonomy. If you learn one concept today, make it this one. This is a must-have for your legal vocabulary. It's the absolute heart of ADR. It means the people actually in the dispute, they're in the driver's seat. They have the power, the autonomy, to design the process that's going to work best for them and their unique situation. And this right here, this slide shows you what a massive shift that is for you as a lawyer. In litigation, you're trained to ask a rights-based question. Who's right and who's wrong according to the law? But ADR lets you ask an interests-based question. What do these people actually need to solve this problem and move on? It just opens up a universe of creative, flexible solutions that a judge simply can't order. Okay, let's get practical. To be effective in the world of ADR, you have to speak the language. So let's lock in 5 absolutely essential vocabulary terms. These are non-negotiable if you want to be taken seriously as an international legal professional. First up, the arbitrator. The easiest way to think about an arbitrator, they're basically a private judge. A neutral expert chosen by the parties who listens to all the evidence in private and then makes a final decision. Now, this one is huge. In a courtroom, you have a plaintiff and a defendant. Forget those words in arbitration. The person who starts the case is the claimant, and the other side is the respondent. Getting this right is one of those little things that instantly shows you know what you're doing.
Next up, the award. This is so important. At the end of an arbitration, you don't get a judgment or a verdict. You get an award. That's the official name for the arbitrator's final written decision. And because of those treaties we talked about, an award has the same legal punch as a court judgment anywhere in the world.
All right, here's the word you're going to hear all the time: binding. When a decision or an award is binding, it means it's the end of the road. It's final. It's enforceable. And this is the critical part. There's almost no way to appeal it. When it's binding, the case is well and truly over.
And last but not least, the hearing. Think of the hearing as the main event. It's the arbitration equivalent of a trial. It's the formal session where both sides present their evidence and make their case to the arbitrator. The big difference? It's all done in private, and it's usually a lot less formal than a public courtroom.
So you've got the concepts, you've got the vocabulary, but how do you actually decide if ADR is the right move? Let me be clear, it is never an automatic yes. Your job as a legal advisor is to be a strategist, to weigh the good and the bad for your client's specific situation.
And this is where your communication skills as a lawyer are key. On one hand, you have to explain the advantages, the pros, the upsides. We're talking about things like speed, saving money, and keeping the whole dispute private. But you also have to be very clear about the disadvantages, the cons, the drawbacks. And the biggest one is that when you agree to a binding process, you are essentially giving up your right to appeal. There's no do-over if you don't like the result.
So it really all boils down to this one single trade-off. You are trading away the safety nets of the public court system, like extensive appeals, in exchange for the speed, privacy, and finality that ADR brings to the table. It is a massive strategic calculation, and it's one that needs your expert advice.
And that leaves us with this question, a question that's going to be a huge part of your future practice. Because helping your clients navigate this exact fork in the road, choosing between the old public courthouse and the modern private world of ADR, that's going to be one of the most important things you ever do for them.